Yes, absolutely.
Right? He says, my Council of Ministers shall take appropriate steps as soon as restoration of normal conditions have been completed to convene a National Assembly based upon adult suffrage. Then 5, the Constitution to be framed by the National Assembly shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing for the freedom of conscience. Now, what appears to have happened was that before elections were held, by adult suffrage, they composed the Constituent Assembly. That's how the Constituent Assembly came into existence. Now, your whole argument is, of course, that what is to be done by a Constituent Assembly cannot really be done by a Legislative Assembly, and therefore less so by the central government assuming the character of a Legislative Assembly under 356. That's the. What happens then if there is no Constituent Assembly?
I'm sorry, Mal?
What happens if there is no Constituent Assembly? Do you have to create a Constituent Assembly afresh?
Well, that is precisely between 1948 consultations.
No, now what would happen? Suppose they keep aside the procedure which they followed. We're keeping that aside for a moment. 373 postulates the Constituent Assembly has to give its recommendation on any proposal for abrogation.
Right.
Suppose the president were to move a proposal for abrogation. According to you, how would that be effectuated now, say in post-1957 India?
Let me answer that in two parts. Number one, what my lord is putting to me is in 1948, they contemplated a National Assembly.
Right.
But your lordships must remember that those were years between 1948 and 1950, especially after 1947, after the Instrument of Accession was signed, Mullah. After the Instrument of Accession was signed, those were transitional periods. And when the Constitution came to be framed, there was a dialogue between the state of Jammu and Kashmir, that then stood through the Maharaja, and the government of India. And both of them decided that we will put this into the Constitution, that is 370, use the term Constituent Assembly, and you will then set up a Constituent Assembly to frame the Constitution and decide what you want to do. You must understand the historical context in which this happened. This has not happened in an isolated fashion. The Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K Constitution contemplates that this Legislative Assembly will have no role in regards to the amendment of the provision of the Constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of a
next question is, supposing there was no Constituent Assembly. That's the next
question. How do we, then what constitutional mechanism would be envisaged then?
If there were no Constituent Assembly and your lordships were sitting in 5, I would answer that question, but luckily we have a Constituent Assembly. But I can't answer a hypothetical question as to what would happen.
How would you then put into place the constitutional machinery? Because there has to be machinery. It can't be that, because there is no Constituent Assembly, because there is no Constituent Assembly, you cannot at all deliberate on a proposal for abrogation or modification of Article 370.
Your lordship is putting to me, supposing the Maharaja refused to have a Constituent Assembly.
No, take 2019.
I'm sorry?
Take 2019.
Yes.
When the Constituent Assembly has been convened, the Constituent Assembly has drafted the Constitution.
Yes.
Therefore, its role has come to an end. There is no Constituent Assembly.
Correct.
2019. The government the president wishes to modify Article 370.
Yes.
Now, we've seen the process which they followed.
Yes.
What, according to you, would have been the constitutional process to...
No constitutional process, because the Constitution of Jammu and Kashmir said, in terms in 147, that no such bill can be introduced in the legislature.
Oh, by them?
By them.
I'm talking about, no, by them, where the Constitution as it applies to the state of Jammu and Kashmir, which is part of the law applicable in Jammu.
So, according to you, no constitutional procedure
shall
be initiated for abrogation of Article 370 at all.
I've been saying it's permanent. Why do you, Mullah? I've been
the argument is that after 1957,
yes,
the president ceases to have any power under Article.
That was temporary between 1951 and 1957. Where do you get that power from? You see, the point is, Malaj, at that time it was temporary because there was nothing in place.
After 1957, sub-article 3 has become OTOs now.
Yes, no, Malaj. It can happen as a political decision. The Jammu and Kashmir government and the legislature of the state unanimously did what? And they merged. That's another issue altogether.
So, Mr. Sabal, according to you, neither the assembly can do it,
Yes.
nor the parliament can do
Yes,
it.
yes.
What you are saying is, while other provisions of the constitution may be capable of amendment through a process envisaged for amendment,
Yeah.
other than, of course, if it is hit by basic structure,
Correct.
this is one provision which can never be amended.
Well, and let it put it differently. But let me put it, under what power will this take place? Let's assume, Manoj, they can do it. If my lords
I'm just
put the
thinking
question to
aloud,
me,
to have a
under which provision of the constitution can they do it?
Having a permanency, the whole concept is that constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically
Then
saying,
a political act can be, but there can be a political act.
And those negotiations,
Clause 1 is the answer to this. 370 clause 1, bit by bit, modifications, exceptions, applications have come. Now, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can
modifications.
Parliament not have amended the constitution exercising the 368 power to abrogate 370?
No.
Which means, therefore, that there is a provision of the constitution, apropos what fell from Brother Justice's call, that according to your submission, there is a provision of the constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note
So we are creating then a new category apart from basic structure.
No, not
That 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used, continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is it-
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, it's now, it cannot be.
not done.
want to put
Yes.
is that 371, according to 370 subclause 1, itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the constitution applies to the state of Jammu.
Yes.
Then what remains of 370?
Nothing.
Then the only,
Then to say that you can,
It can
in
be
a sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So I'm
1.
saying therefore said that
Yes.
371, according to you,
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are saying
be.
that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I'm.
This is what we are saying.
Yes,
That-
yes.
That may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that will, I think, Mr. Shankar Narayan, what will happen is, we are following a certain line and a link and a syntax, so. I mean, I think, we might be broken up in the nuance of.
Respect Mr. Sibal, he knows the law. We also, therefore, didn't jump and answer the questions.
I don't think, see, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi
can.
said, no, this is not what I'm saying, I'm saying something different. So we'll have to see where the call, right?
You
I
can say
understand, so
something
your
different, there's
argument
no
I've
issue at all.
understood at your own term. Which is that you can keep the shell, but the process is 2, 370 and
So
1.
there is another interpretation.
Well, the problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
Please
So
say
why
there
not-
is a constitutional process by which it can be done under 371.
No, you can't do away with
Okay, I-
370 sub clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the Constitution in
Right,
force.
right.
Can you not say that another order be issued that it can under one saying that all the provisions of the Constitution apply, and list them all of them and say all of them apply?
You know, the problem there is if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
Mr. Sibal,
It doesn't apply to the other parts.
insofar as clause D is concerned,
Yes.
there are no limitations. If you read it, much of the provisions of the Constitution shall apply in relation to the state subject to such exceptions and modifications as the precedent may by order specify.
Correct,
This is done by second proviso,
correct.
provided further that no such which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government.
Yes.
The treaty of accession, defense and commerce
That's
and so on.
correct, that's correct.
So if-
And the lists involved there.
And the list involved.
Correct.
So suppose if the parliament
Yeah.
decides to make the entire provisions of the constitution applicable to Jammu and Kashmir.
Yes.
Limitation under clause D.
Yes, there is. That's the point I'm making, Malaz. Because the structure of 370 and in the context of the legislature of Jammu and Kashmir is that the residuary power remains with the state.
Because the distinction is that insofar as those powers
Concurrent
under-
list and instrument of accession are two separate things, but there's no issue there. They can do it, both under 371, no issue.
insofar as instrument of succession, those
Only
entities are
four- only
concerned,
four items.
Their only requirement is consultation. Consultation.
That's correct.
Insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, Mother. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process. Even under 370 sub-article 1. That's the problem. But I see the point that my lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement,
No,
the
but
philosophy of basic structure.
All right, let's not talk of 2023, Madad. In 1950, what was the position? This was the position. That it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament,
no,
how
this-
can we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic structure, Madad. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact.
Then what happened?
Unlike other states where Junagadh, he didn't agree, you know, as a political act, you took over Junagadh. He ran away, the Maharaja ran away,
But that, Mr. Sibal, there, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another, which forms a part of our constitution, then such a sovereign compact is capable of being overridden
That's all right, Madad. So then we could.
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Madad. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed. consistent with the interpretation of 370, having taken that position that we need the consent of the Constituent Assembly.
Is this the Constituent Assembly according to you?
Yes,
Yes.
that's right. That's the procedure.
That we've
We're
appreciated
only
that
on that.
submission. Yes, of course, we have appreciated that
We are
submission.
limited only on that.
That the
Large-
process, in other words, your contention is that the process which the government of India followed assumes that the proviso to clause 3 applies,
Yeah,
that this change has to be brought in through a Constituent Assembly.
correct.
But this was evidently not the Constituent Assembly because A, it was the Legislative Assembly that you have invoked, and two, even that Legislative Assembly was dissolved and ultimately Parliament was exercising that power under 356.
Now, the larger question, supposing your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. But we're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the Constitution, if they follow them, maybe, whether that may be valid, may not be valid, but I can't answer that question in a vacuum.
But
My lord is right. What my lord is putting to me, the problem is the residuary power is with the state, and I've shown your lordships, Mullad's provision after provision, right from the Delhi Pact in 1952, that that's the case.
But then what happens to Article 363A?
350?
363A. Because that also earlier the recognition was on the basis of the pact between the various